Good day, Crime Talk aficionados. It's Sunday, which means it is the weekly recap of all the top stories throughout the week, located in one convenient location. I hope you enjoy it. Have a wonderful weekend. We'll see you Monday. And remember, the Constitution matters.
All right, lawyer.
Judge in the Karen Reed case is to rule shortly whether there is misconduct by the defense team. Now, not to be outdone, of course, the defense has alleged that the case should be dismissed for outrageous governmental conduct. Now, the hearing is set for Tuesday. Now, the judge presiding over the case, like I said, will rule as early as tomorrow if there was misconduct by the defense in their handling of two experts. The case is due back in the Dedham's Norfolk Superior Court for the continuation of a pre-trial hearing. This pre-trial hearing was initially continued when the judge decided that she had grave concerns, which was extended to Tuesday, February 25th. And the special prosecutor, Hank Brennan, accused the defense earlier this month of lying about dealings with the crash experts from ARCA. They're the accident reconstruction peoples, Dr. Daniel Wolf and Dr. Andrew Rentschler, which was bringing the hearing on Tuesday, February 18th, to an abrupt end. Well, both experts testified on behalf of Ms. Reed in the June 24 trial and stated that the injuries to Reed's Boston's police officer's boyfriend, Mr. O'Keefe, weren't consistent with a vehicle strike. Now, Special Prosecutor Brennan has alleged that the defense hid communications with ARCA and more than $23,000 was paid to them by the defense, even though they were originally hired by the federal authorities. Now, you may remember the defense called him as a witness. There was some question of whether they were going to, actually call experts that they weren't exactly sure of what they were going to say, so to speak. And the testimony came out that the defense experts were doing it just to for the good of mankind, to make sure that Karen Reed was not wrongfully convicted in any way. Well, like I said, it turns out there may have been a financial arrangement. And if that was the case, then guess what? It should have been disclosed. It wasn't, and it left kind of a bad taste in the government's mouth, so to speak, because they could have cross-examined that they weren't doing it just for the good of humanity and society. They were actually doing it for money. Anyway, we digress. Anyway, defense attorney Robert Alessi responded to Mr. Brennan's claims during last week's hearing, arguing to the court that there was nothing shady about the interactions, accusing Mr. Brennan of trying to mislead the court. And Mr. Alessi confirmed that Reed's legal team did in fact pay ARCA after the trial, but Mr. Brennan maintained that the information should have been shared publicly. And the whole issue is whether there's going to be some sort of misrepresentation to the court by an officer of the court. I think it probably should have been disclosed. It should have been disclosed up front, and we wouldn't be having these issues at all. Anyway, of course, any attorney, unless they want to risk malpractice, is going to make a communication with that expert, which was argued by Mr. Alessi. At least tried to contact them, and they did, but they made it sound like they never talked before. Special Prosecutor Brennan responded, "It is the bias, the relationship that is critical, and that was hidden from the court." Anyway, the judge ended last week's hearing without deciding if the defense would face any consequences. However, she previously suggested that this could have profound effects on the future of the case. Remember, Alan Jackson and most of the defense team is admitted pro hoc vice, which means they're not technically licensed in the Commonwealth of Massachusetts, and they could have their pro hoc vice status eliminated. However, that raises some choice of counsel issues, and so the question then is if the judge is going to sanction the defense, if at all, whether it's done now or at the end of the trial. Normally, that's what's done. If there's going to be some sort of sanctionable offense, it's done at the end of the trial. The judge will then contact the Bar Association and let those proceedings roll from there. We'll see how things go tomorrow. Anyway, the hearing also comes after Ms. Reed's attorneys filed a 147-page motion to dismiss the case against their client on the basis of extraordinary governmental misconduct. In the pleadings, the defense accuses the Commonwealth of destroying exculpatory evidence, withholding exculpatory evidence, and interfering with the jury. Now, the prosecution fired back in a 15-page motion to Reed's motion, arguing that it should be denied because the defense claims do not raise any substantial issues. We're going to have to wait and see. I think the allegations made by the defense have pretty much been made. There's been no sanctions. I don't see the judge saying, oh my gosh, all of a sudden now the prosecution has done something wrong. First, you have to show bad faith. I don't think, based upon that pleading, at least what we were able to read, which is a good chunk of it, is that there's anything that's bad faith. Maybe incompetence, but incompetence doesn't rise to the level of bad faith. And of course, when you are being attacked, what do? You attack as well. That's what the defense was doing. Now, for those who do not know, Miss Reed is accused of hitting her then Boston police officer boyfriend, John O'Keefe, with her Lexus SUV on January 29th and leaving him to die after a night of drinking in the cold snow. The defense has sought to portray Miss Reed as the victim, saying that Miss O'Keefe was actually killed inside the Albert family home and then dragged outside and left to die. Of course, the dog maybe take a bite out of him too, according to the defense theory. The retrial of Miss Reed is scheduled to begin in April of 2025, and the judge declared a mistrial back in July of 2024 after finding jurors couldn't reach a unanimous verdict on all of the charges of second-degree murder, leaving the scene of a crash and manslaughter. Now, Miss Reed, who although did not testify in her first trial, which she has an absolute right not to do, and frankly, as I've said it before, I would have found Miss Reed not guilty in the first trial based upon the evidence that was presented or the lack thereof. I think the defense case's wheels are kind of coming off. Things aren't going exactly the way the defense was hoping. I think they really hoped that maybe they would have this case dismissed. Clearly, that's not going to take place. The prosecution always does better the second time around. As we've seen that from pretrial motions, the prosecution has been attacking everything that Miss Reed did in the first trial, which frankly, I don't think the prosecution really expected a lot of that to come out, even though it was disclosed. I don't think they expected it. And the reality of it is I don't think they were prepared for it. But Mr. Brennan, obviously very experienced attorney, come on the prosecution team to come in for the big win, so to speak. So like I said, Ms. Reed, although she didn't testify, perfectly her right to do, did an interview with a Boston outlet and says that she has nothing to hide and that she has been framed for murder. And I'm sure the prosecution may play a portion of that interview at the trial. I'm not sure why the defense would have agreed to that interview. Lori Vallow says she's going to be exonerated. That's right. She says she's going to be exonerated, and she's telling her story to Dateline. We get to see it this Friday night. Here's a quick little preview, though. That's right. Now, as you may know, Lori Vallow is behind bars currently in Arizona, specifically Maricopa County, where she is awaiting the trial related to the death of, that's right, husband number 4, Charles Vallow. Husband number 5, the one that got the death penalty, Chad Daybell, is currently on death row there in Idaho. Obviously, both of them were convicted for the death of J.J. Tiley and Chad Daybell's now deceased wife, Tammy. The interview is apparently a little combative, according to insiders who have already seen the video. So that ought to be exciting. But we do see, she says she's going to be exonerated. She says that they both will, referring to Chad. She says, quote, "I have seen things in the future that Jesus showed me when I was in heaven, and we were not in jail, and we were not in prison." End quote. Lori Vallow. Okay, if she was represented by an attorney, file that motion for competency immediately. But since she's her own attorney, I guess she can do that. And guess what? She can do interviews as well. I wonder if that's against her attorney's advice. Oh, that's right. She is her attorney. Anyway, as you may recall, Lori Vallow was sentenced to life in prison back in 2023. The deaths of Joshua J.J. Vallow, Tylee Ryan, and Tammy Daybell. A separate jury found Chad Daybell guilty of all the same crimes, and he got the death penalty. She did not, because there were discovery violations by the prosecution, and she would not waive speedy trial. And therefore, as a sanction against the prosecution, the judge threw out the death penalty, probably knowing she would never face death given her mental inability to remain competent. For example, because she was there for 10 months awaiting trial there in Idaho at the state mental hospital, being restored to competency. Now, this Dateline special is going to include Rexburg Police Detective Ray Hermosillo, Madison County Sheriff Ron Ball, Madison County Prosecutor Rob Wood, and retired FBI Agent Douglas Hart. It ought to be good. We'll be watching it Friday. Will you? Now, remember the other day we told you about Judge Hippler saying enough is enough of everything being filed under seal in the Bryan Kohberger case. I totally agree with the court's rationale. Nothing is so sensitive under the rules that it needs to be kept in secret. And additionally, a lot of this information is going to come out at trial. So why are we playing these games of somehow keeping everything secret? Well, what has that done? Well, we got to be able to see the motions that have been filed. And what motions do you say, Scott? Well, motions in limine. Motions in limine are motions filed by both sides saying, hey, Your Honor, we want you to rule pre-trial whether this information, more than likely it's admissible, but we think it may be prejudicial. And so don't allow it in. Well, both sides have got a stack of motions. So I'm going to go over an overview, and then we'll go through in greater detail these motions, because it provides a lot of insight where the case is headed. And once again, ladies and gentlemen, like I told you, you file in motions something out if you are the defense. And there's a lot the defense wants to keep out. Now, for those who don't know, back in November of 2022, 4 University of Idaho students were found dead, killed, stabbed to death in their off-campus home in Moscow, Idaho. Now, roughly 9 miles away in Pullman, Washington, guess who happened to live there? Bryan Kohberger. He was a student enrolled there at the university in a PhD program. Now, the students, Madison Mogan, Kayla Gonzalez, Zaina Kernodle, and Ethan Chapin were all obviously deceased. And guess what? Bryan Kohberger has been accused of those 4 murders as well as the burglary, and he faces the death penalty. Now, Bryan Kohberger's attorneys have tried and thus far failed to get the death penalty taken off the table on grounds that it is unconstitutional, that it somehow does not comport with evolving standards of decency, and that it is applied arbitrarily. All things that the Supreme Court says you can't have if you're going to have the death penalty. So in their most recent attempt, they are now trying to say Bryan Kohberger, if convicted, and we'll give him the presumption of innocence, but if convicted, capital punishment should not be imposed because he suffers from autism. Let me explain, ladies and gentlemen. Some people may say, he's got autism. He's probably super hyper-focused. We know lots of people that have reportedly have autism, and they're very high-functioning individuals, but yet they're maybe a little socially awkward. There's some people that could be non-functioning. Clearly, that's not the case because Bryan Kohberger was in a PhD program. This is something that the defense will ultimately bring up in mitigation if there is a conviction. In the sentencing phase, it is mitigation. And there's actually a motion where they say, hey, we don't want the prosecution to flip the script on us because this is our mitigation and you can't use it as an aggravator. All right. We'll talk about that in a minute as well. But needless to say, these attorneys are doing what they're supposed to do. This is good lawyering. And we, as a community, as a society, should expect nothing less for anyone charged with obviously a heinous crime where they're facing the death penalty. They should get excellent representation. And then obviously if there's a conviction, there's less likelihood that the matter will be reversed on appeal if they have effective and competent counsel. Clearly, Mr. Kohberger has very effective and competent counsel. You may not like some of the motions that are being done. You may not like some of their tactics, but they are doing what the defense attorney is supposed to do: hold the government to their burden of proof, challenge the evidence that the government intends to bring forward, And that's where we are today. So like I said, in Mr. Kohberger's latest attempt to avoid the death penalty, his attorneys have filed a motion asking the court to note that he has autism and that it exposes him to an unacceptable risk that he will be wrongfully convicted of murder and sentenced to death. Now, this 28-page motion was unsealed, and like I said, because the judge is allowing everything to be unsealed now, and they're saying that if he is found guilty, it would violate his Eighth Amendment right to remain free from excessive punishment because his autism spectrum disorder diagnosis. Now, he also faces one count of felony burglary. And in this case, the defense notes where jurors will be forced to determine whether Mr. Kohberger will live or die. Mr. Kohberger himself is essentially a piece of evidence to be examined and evaluated. Every movement and expression is subject to an analysis. His attorneys wrote. And they say that Mr. Kohberger, who is studying criminology at Washington State University, is expected to stand trial this summer, and the prosecution tends to seek the death penalty if he's convicted. All right, we know that, but that's in the pleadings. Now, Mr. Kohberger's autism spectrum disorder prevents him from being sentenced to death in a manner that accords with the constitutionality requirements of proportionality and reliability, his attorneys argue. Apparently, Mr. Kohberger's disorder has a significant impact on his life, according to a comprehensive neurological evaluation conducted by Retrial, a New Hampshire-based neuropsychologist. Now, the autism spectrum disorder is a developmental disability that is caused by a difference in the brain, according to the good doctor. And people with autism tend to have problems with social communication, interaction, and restricted or repetitive behaviors. Now, the filing also notes that the core diagnostic feature of autism, such as lifelong issues interacting with people, and this includes the diminished ability to understand people's reactions and difficulty identifying the emotional or mental state of others and how to respond appropriately. Basically, what they're saying is the person can't read the room. Now, while autism isn't an intellectual disability, though some people have both, the attorneys argue that some people with the disability share similarities, especially in regards to prior court findings over the elimination of the death penalty. They argue that back in 2002, the United States Supreme Court ruled that executing people with intellectual disability violates the Eighth Amendment. That hasn't included neurological disabilities such as autism, but as they argue, well, it should. And that sentencing people with autism spectrum disorder to death is also a violation of their constitutional rights. His attorneys also noted that sentencing people with intellectual disabilities creates an unacceptable risk of wrongful execution because the defendants aren't able to help in the mitigation part of their case. Now, you may remember, this is going back to people that involved special needs. They used to use the R word for that. Very low functioning. Makes sense. Probably shouldn't kill people that are low functioning, no matter how heinous the offense that they have been convicted of. Anyway, specifically, the court found that the defendants couldn't meaningfully assist their attorneys. Their demeanor might give unwarranted impression that they lack remorse and that they are typically poor witnesses. They go on, specifically saying Mr. Kohberger, that he displays... Listen to this, that he displays extremely rigid thinking, lingers on specific topics, processes information on a piecemeal basis, and struggles to plan ahead, which affects their attorney-client relationship and their ability to prepare for trial. He also demonstrates little insight into his own behavior and emotions, she adds, which basically means they're having difficulty dealing with him processing some of the information. Now, it doesn't rise to a level of competency, but once again, it just kind of goes to show that he may function a little bit differently than others, and he may not appreciate the severity of what may have allegedly taken place at his hands. So, no matter how helpful Mr. Kohberger may wish to be, it is simply not possible for him to aid counsel in a way that someone without the deficits accompanying autism spectrum disorder would be able to. Now, the neuropsychologist, Dr. Orr, said that his tone and cadence are abnormal, his interactions lack fluidity, and his language is often over-inclusive, disorganized, highly repetitive, and oddly formal. He's easily distracted by sounds or activity, often needs questions repeated, and uses abrupt, matter-of-fact phrases that could be considered rude. He also has exhibited compulsions around hand washing and other cleaning behaviors. Since childhood, these symptoms of Mr. Kohberger's autism spectrum disorder will alienate him from the jury and significantly hamper his ability to make a persuasive showing of innocence or of mitigation. The filing also pointed out two of the states, Ohio and Kentucky, bar people with serious mental illnesses from being sentenced to death, but autism, well, that's not included in those jurisdictions. Those states specifically say that schizophrenia, schizoaffective disorder, bipolar disorder, and delusional disorder are possible exemptions to the death penalty. Now, Ms. Taylor is concerned that there is a substantial risk that Kohberger's demeanor, because of his autism diagnosis, will create an unwarranted impression of a lack of remorse. People with autism often emerge in repetitive, self-stimulating behaviors such as hand flapping, finger snapping, and body rocking. A juror seeing the defendant engage in any one of these behaviors while sitting at counsel table during the murder trial would perceive the defendant as strange, out of control, and even disrespectful of such solemn proceedings. She added that the subtle indicators of autism could be just and damning for capital defendants, if not more so. An inability to make eye contact could be interpreted as guilt or shame, while facial expressions, contrary to the tone of the proceedings, could be seen as cold or lacking remorse. Now, Mr. Kohberger specifically subtly rocks his upper torso when listening to someone, has limited facial expressions, and exhibits atypical eye contact, such as an intense gaze, which the neuropsychologist observed during her evaluations, according to the pleadings. Now, while a lack of facial expression or abnormal eye contact are indicative of autism, Taylor said that to hundreds of thousands of online commentators who developed a cottage industry devoted to analyzing her client's every movement, these symptoms are sure signs of guilt. These widely viewed and highly prejudicial media reports, draped in the language of expertise and analysis, demonize Mr. Kohberger for his disability in an environment such that it is tainted by rampant and vitriolic conjecture. It is impossible for Mr. Kohberger to receive individualized sentencing determinations, including full and careful consideration of mitigation evidence that the Constitution demands whenever the state seeks to extinguish a human life. Now, Mr. Kohberger can't conduct himself in a manner that aligns with societal expectations of normalcy. Ms. Taylor goes on to say that there is an unconscionable risk he'll be executed because of his disability rather than his culpability. Ms. Taylor added that Mr. Kohberger's facial expressions have already been given a sinister meaning in the decision to transfer Mr. Kohberger's case over there to Ada County. They acknowledged that the extraordinary media attention of this case obviously played a factor. She pointed to various news articles that reported on allegations that Kohberger made creepy comments to staff at a brewery in Pennsylvania, made female students at Washington State feel uncomfortable, and lost his job as a teaching assistant for failing to meet normal professional behavior. Given his difficulty interpreting social cues, these allegations could be explained by his autism. The defense is arguing, adding that it was no surprise he came across as socially awkward or struggled to adapt to professional norms. She called his behavior hallmarks of his disability. There is no need to speculate about what impact Mr. Kohberger's autism spectrum disorder might have on his disability to present a meaningful defense, they argued. This is interesting. Oftentimes, you don't get the perfect defendant at the table. I would think that if I was the defense attorney for Mr. Kohberger, that I would say, Judge, I want to be able to bring this up in voir dire and kind of give a general explanation that he suffers from autism, and these are some of the things. So don't read too much into it. I would think the judge would possibly allow that. But to be able to say, let's take it off the death penalty, this judge is going to deny this motion. But it's good lawyering, all right? And it's good mitigation for the penalty phase if he is ultimately convicted. So something to think about. Now, next, on the Bryan Kohberger matter. What the heck is going on with this DNA? Whose DNA was under Madison Mogen's fingernail? Well, let's talk about it. So, some more pleadings in the Kohberger case have revealed that DNA from 3 individuals was found under the victim's fingernails of murder victim Madison Mogen. Now, in this document that was unsealed yesterday, the accused quadruple killer's defense team reveals that testing of Mogen's left fingernail clippings unearthed DNA evidence from 3 unknown individuals. Parts of the documents have been redacted, meaning the fingernails tested remain somewhat unclear. However, the defense indicates that the comparison to Kohberger's DNA was inconclusive and that he could neither be confirmed or eliminated as a possible source. However, this is the first time it has emerged that there could be additional DNA evidence from the crime scene beyond the leather knife sheath, as well as the blood drop on the railing and the glove outside. Now, a critical part of the case against Mr. Kohberger comes from a brown leather knife sheath found close to Madison Mogen's body at the scene. That's right. The only channel that has their own K-bar, still has a K-bar, didn't lose the knife with the sheath. And I've had this since 1988, ladies and gentlemen, when I was a young lad getting out of boot camp. Anyway, so according to the prosecution, this touch DNA found on the sheath belongs to Kohberger, and that was obviously used to trace him using the investigative genetic genealogy, which we've talked about several times on this show. Now, the defense is asking the judge to limit testimony about the DNA analysis of Mogen's fingernail scrapings, claiming it would violate Kohberger's right to a fair trial. Now, during grand jury proceedings, the court heard testimony that a 3-person mixture had been found on Madison Mogen's fingernail clippings. The data from that sample was redacted as to Mr. Kohberger, the document states, and the statistical likelihood that Kohberger is one of the 3 individuals whose DNA were found on the clipping is also redacted. Now, the filing details the witnesses testified about the meaning of the term inconclusive. Kohberger's defense team is arguing that the testimony used misleading language, and what they should have been talking about was likelihood ratios, which are different from traditional statistics that court and juries are used to seeing at the hearing. The likelihood ratio is a comparison of hypothesis. It's not a statement of identity or probability of identity. It simply asks the question, given the data, which hypothesis tested is more likely? Statistically, it was assumed that Mogen was one of the 3 individuals. So then 2 hypotheses were then tested, and the 3 people included Mogen, Gonsalves, and 1 unknown, unrelated person to Mogen and 2 unrelated persons. Kohberger's defense argues that at least 4 other unnamed individuals were also tested and that they, like Kohberger, also came back inconclusive. All of these individuals sit in the same shoes as Mr. Kohberger, namely that the likelihood ratio is exclusionary but falls in the range of inconclusive. His defense argues that focusing on Kohberger's DNA being inconclusive would be misleading at the trial. Next, let's get to a little less contentious trial. That's right, the Karen Reed matter. That's right, the Karen Reed case was subject to 2 hearings in separate courthouses on Wednesday. First, Miss Reed appealed a recent decision by the Massachusetts Supreme Judicial Court at a federal court in South Boston. Once that was over, she and her attorneys headed over to Norfolk Superior Court in Dedham for another hearing. Prosecutors obviously have accused Miss Reed of hitting and killing her Boston police officer boyfriend, John O'Keefe, who she was dating at the time, and then obviously hit him with the SUV, allegedly, according to the prosecution, and then leaving him to die in the snow outside of a Canton home back in 2022. She's pled not guilty and argued that she is being framed by several people, including law enforcement involved in her investigation of the case. Now, the first trial ended in a mistrial last summer where the jury was supposedly quite divided. Her second trial is scheduled to begin in just a couple of weeks on April 1st. Like I said, so the day started in federal court where her attorneys asked the federal judge to require the state to bring back jurors from the first trial to poll them and determine if they had acquitted Miss Reed on 2 charges. The federal court seeks what they refer to as habeas, writ of habeas relief, which is a doctrine that allows people to challenge their unlawful detention. It stems from Reed's Supreme Court Judicial Court appeal, in which the highest court denied her request to drop 2 charges against her. And Reed's lawyers make 2 arguments: that a mistrial declared was not necessary, and that the jurors privately voted to acquit Miss Reed. Now, the attorneys representing the state in this particular matter argued, saying that the jury verdicts in Massachusetts aren't final and can't be changed until the moment they are read out loud in open court. Therefore, there was no final verdict. I said that way back when this whole issue came up, and the appellate courts have agreed with me. That's like courtroom 101 type of knowledge. But Chief District Judge Dennis Saylor, the fourth, told the lawyers that the legal question was quite complicated, comparing it to a forest. He said he would make a decision as quickly as possible so that lawyers will have time to appeal, with Karen Reed's trial coming up on April 1st. Then, like I said, everybody after the federal court went to the state court, and there was a hearing there for the defense to argue its recently filed motion to dismiss. The hearing started off with a heated exchange with the judge scolding defense attorney, specifically Alan Jackson, before he started his argument. And the judge was referring to a part of the motion to dismiss, which was largely redacted, which apparently accused a Massachusetts state trooper of tampering with a jury. Now, the defense alleges that Lieutenant John Fanning was in charge of the jury or oversaw the jury in some capacity. Fanning works for the Norfolk County District Attorney's Office and was in a group chat in which Trooper Michael Proctor said disparaging things about Miss Karen Reed. While Lieutenant Fanning was on the text chain where Michael Proctor said he was going through my client's phone looking for nudes, according to Alan Jackson, the judge emphatically denied the allegations. What you state as fact, that Lieutenant Fanning had control or access to this jury, is simply not true, Mr. Jackson, the judge told him, referencing prior conversations regarding candor to the court. The judge also said that it's the court's offices only who are tasked with overseeing the jury. Jackson said his team, other than taking the word of the court, had no factual basis that the information that Lieutenant Fanning had no interaction with the jury was true. So what's the big deal? Well, the defense says that Lieutenant Fanning was the person who reported to the court alleged misconduct by potential Karen Reed friendly jurors, causing her to get dismissed from the case on the last day of the trial. We'll see. There's no evidence to support that, and that will probably be denied. I mean, you can make any allegation you want. It's like you can sue anyone for anything you want, but eventually you got to prove it, and you have to come forth with evidence, not just a simple allegation. Then we got the video. Now, the other major factor in Jackson's argument was that the prosecutors slowly released the Canton Police Sally Port and surveillance video to defense attorneys over years, despite having access to it the day of the alleged crime. Now, some videos were released to the defense as recently as last week. The defense says these videos are exculpatory because they have the possibility of showing the condition of the taillight of Karen Reed's SUV in the hours following John O'Keefe's death. Now, for the Commonwealth to have these video footage for 3 years, making one question was going on with the evidence. What is going on with this evidence? Jackson said, that is bad faith. Jackson also said at one point possible evidence was transferred at the Canton Police with a note on it from the police chief that ended in the term LOL. So in response, the prosecutor, Mr. Hank Brennan, told the court that Trooper Michael Proctor had gathered the video and had not passed it on to prosecutors. Brennan also argued that the condition of Reed's taillight didn't matter, showing various videos to the court where he says it is undisputed that parts of Reed's taillight were already missing, and to attempt to dispute the defense allegations that Proctor damaged Reed's taillight and therefore then planted evidence at the scene to get Miss Reed. And then, of course, to complicate everything, another juror speaks out. Another juror has spoken out with their reaction to the hearing. Now, Victoria George was an attorney herself and an alternate juror in the Reed case, and she sent a statement to one of the local news channels there. I was fair-minded as a juror who left this trial questioning the system's integrity long before the defense filed a motion to dismiss with allegations of jury tampering. The Reed case itself and the fact that it's still being brought has left many in Massachusetts wary, distrustful, and scared of the system. The reality saddens me even more as a lawyer because I remember how much faith I had in our system and as an optimistic law student. Mr. Brennan made an impassioned argument today regarding his alleged concern that some might be questioning the fabric of our entire judicial system. If you truly would like to address the problem, I have a few suggestions, she noted. Perhaps the district attorney's office should be more focused on remedying the systemic issues plaguing it and affiliated police departments rather than continuing to spend millions of taxpayers' dollars prosecuting a case with so many evidentiary issues that it calls into question whether they have even followed their ethical obligations as prosecutors. The Commonwealth has a duty to protect the defendant's rights, and I, for one, would love to see them do so. I wonder who she was going to vote for if she was the alternate that was selected to testify. Listen, I get it. There's things that go on. Everyone is shocked by what takes place here. It's nothing unusual. This garbage goes on all the time. Prosecutors say, oh, I thought I turned it over. We thought it is. In today's age of so much discovery, Judge, we thought we turned everything over. It got saved to a hard drive. We didn't know about it. There was nothing bad faith about it. Your remedy is you want a continuance, you get a continuance. That's what the remedy is more than likely going to be. People who don't work in this system know that this happens all the time, or they don't know. People that don't work in this system, judicial system like this every day, are shocked by this. This happens all the time. And prosecutors get a pass. The defense raises issues. They're looked on as bad guys, right? But unfortunately, it will continue. All right. But it's because of defense attorneys out there saying, Judge, you can't do that. Judge, they didn't turn it over. Yes, there is bad faith. I mean, I've recently seen 2 cases dismissed here in the state of Colorado when prosecutors failed to turn over evidence that had been requested, asked for, and the state had, and it was their obligation to turn over. And they said, oops, I thought we turned it over. Judge said, nope. So this happens all the time. Now, does it ruin your faith in the judicial system? It shouldn't. All right. Let me tell you why. There's a quote that says, the American judicial system is absolutely terrible, but it's better than anywhere else in the world. Now, I know some people say, no, my system in what other country is better. Okay. But we have an adversarial system. Somebody makes an allegation. The other side says, that's not true. Let me tell you why it's not true. Or they say, well, it's kind of true, or it is true. But through that adversarial system, the truth comes out. It's when you don't allow that to take place, let the jury decide. The jury could say pox on both your houses and find her not guilty. We think you're unethical, Mr. Jackson, and we think the prosecution is unethical as well. Something to think about. All right. So what are we going to do next? There's still 2 motions to argue in this case, plus some more motions in limine, obviously regarding evidentiary issues ahead of trial, which means, guess what? They're going to be back in court on March 18th. The judge will also make a decision on a number of outstanding motions at that point, if not before then, if she issues a written order. I said it yesterday and I'll say it again, or the other day I said it, that this is turning into like an O.J. Simpson case. This is a maybe 7-day trial. This is maybe a half a day or 1 day of argument on motions, and that's it. This judge, Cannon, whatever her name is, however you pronounce it, doesn't really matter. The judge, she's turned into the Judge Ito of the O.J. Simpson case. Has no control, and just seems like it's dragging on and on. Anyway, and so then final recap. Obviously, Miss Reed is charged with second-degree murder, manslaughter while operating under the influence of alcohol and leaving the scene of a personal injury and or death. Everybody knows Kayla Gonzalez, her best friend, Madison Mogan, roommates Xana Kernodle, and Kernodle's boyfriend, Ethan Chapin, were all stabbed to death inside their off-campus student home. And the 3 women shared with their 2 other roommates there in Moscow, Idaho, back in November of 2022. Now, Bryan Kohberger, obviously, given the presumption of innocence, a PhD criminology student, has been charged with their murders and 1 count of burglary, and ultimately faces the death penalty if he is convicted, and his trial that gets started here in August. Well, guess what? This new judge, I like him. He is unsealing things, and he is of the mindset that this should not be kept from the public, and I thank the judge for doing this, okay? The public has a right to know. Frankly, it's not a lot of stuff we didn't know, but it helps us give just a little more context, and it's what the prosecution believes is the truth, or what they believe is the truth. And now the defense has an opportunity to challenge it. All right. Now, I think, and like I said, I'm a defense attorney. All right. I like when the underdog, which is the defendant, wins. All right. But I'm also a realist, right? Everybody thinks, oh, you're a defense attorney. You just drank the Kool-Aid, and everybody charged with the crime is, not guilty. Not the case at all. As an attorney, you have an ethical obligation to advise your client, right? And to meet their goals. And sometimes that's mitigation, which means the least amount of punishment for what they may have been accused of doing, which they have to plead guilty to, right? So you're constantly evaluating all the facts that are coming in. And you have to be realistic to the client. And you have to be able to say, that's a bad fact, and I'm not sure how to get around it, right? As the old saying goes here at the Reich Law Firm, why are we going to let the facts get in the way of a good defense? Well, we say that in jest because you cannot ignore the facts, all right? So these new filings reveal for the first time the panicked text messages sent by the surviving roommates, Dylan Mortensen and Bethany Funk, moments after the slaying, as well as the chaotic 911 call transcript around 8 hours later. Now, in the early morning hours of November 13, Mortensen came face to face with the masked intruder inside the home and made a series of calls and texts to her roommates. Only Funk answered. The others didn't because they were dead. At around 4 a.m. on November 13th, 2022, Mortensen, whose bedroom was on the second floor, was awoken by noise in the 3-story home and heard a voice say, "There's someone here," according to the court documents. She also heard what sounded like whimpering coming from Kernodle's room and a man's voice saying, "It's okay, I'm going to help you." Mortensen told investigators she had opened her door and peeked outside 3 times. The third time, she said she saw a masked man with bushy eyebrows and dressed in black walk past her door and head towards the sliding back doors of the home. In the unsealed court filings, it has been revealed that a terrified Mortensen then called her slain roommates Gonsalves, Mogan, and Kernodle, as well as Funk, between 4:19 a.m. and 4:21 a.m., desperately trying to find out what was going on. All the calls went unanswered. And between 4:22 and 4:24 a.m., Mortensen and Funk then exchanged a series of texts about her sighting of the man. "No one is answering," Morton texted Funk. "I'm really confused right now," she wrote. Mortensen then sent 2 unanswered texts to Gonsalves. "Kaylee, what's going on?" She got no reply. In a back and forth with Funk, the 2 younger students are seen trying to piece together what was going on inside their home. "Yeah, dude, WTF," Funk texted. "Zaina was wearing all black," she added in another message. Mortensen texted Funk, "I'm freaking out right now." "No, it's like ski masks almost," she added in an apparent reference to the man that she had seen inside their home. Now, when Funk responded, "STFU," and then actually, Mortensen added, like he had something over his head and a little mouth. "I'm not kidding." And "oh, I'm freaked out," Mortensen said. Funk agreed, "So am I." Mortensen then said her phone was about to die, and Funk urged her to run downstairs to her bedroom on the 1st floor. "Come to my room. Run. Down here." After the text exchange, Mortensen then tried calling Chapin, Gonsalves, and Kernodle another time. She also sent a text message to Gonsalves at 4:32 saying, "Please answer." In a separate court filing, it was revealed that Mortensen did go down to Funk's room, and the 2 young women ultimately fell asleep. The following morning, starting at 1:23 a.m., Mortensen then sent texts to their other roommates. "Please answer," she texted Gonsalves. "Are you up?" she texted Mogan. And to Gonsalves, "Are you up?" Mortensen then had a text exchange with her father at 11:50, called a neighbor known as EA, the documents show, and minutes later, a 911 call was placed from Funk's cell phone. The distressing transcript of the 911 call, also released for the first time, shows that the call was made after an individual known as HJ had found Kernodle's body inside the home. In the call, the caller described the 20-year-old as being passed out and not waking up. "Hi, something has happened. Something happened in our house. We don't know what." The call begins. The dispatcher is told that Kernodle is passed out, was drunk last night, and is not waking up. When asked if she is breathing, the dispatcher is told no. Kernodle is not mentioned by name, and there's no mention of the other 3 victims, suggesting that they have not yet been found. There's also no mention of the bloody, violent scene. The caller also mentions Mortensen's signing of a man inside the home hours earlier. "Oh, and they say some man was in the house late last night," a voice says. The call is disjointed as the phone is passed between EA, HJ, Funk, and Mortensen during the ordeal. Throughout the call, the dispatcher hears constant heaving, breathing, and crying. Now, towards the end of the call, a different voice, believed to be that of an officer, says, "I think we've got a homicide." Now, the release of these details comes as both the prosecution and the defense continue to file a flurry of court filings in this case. Now, obviously, Mr. Kohberger is due in court on April 1st.